Welcome back to SCOTUS Oral Arguments and Opinions. In this episode, we'll discuss the June 27, 2025 Supreme Court opinion in the case called Trump, President of U.S. versus Casa in Key, case number 24A884. This case was consolidated with Trump, President of U.S. versus Washington, case number 24A885, and Trump, President of U.S. versus New Jersey, case number 24A886. There may be more opinions today, so stay tuned. Please note that this summary is read by an automated voice. In this case, the Supreme Court ruled 6-3 that federal district courts lack authority under the Judiciary Act of 1789 to issue universal injunctions that prohibit government enforcement of policies against anyone beyond the named plaintiffs. The case arose from 3 lawsuits challenging President Trump's executive order attempting to end birthright citizenship, where district courts had issued nationwide injunctions blocking the order's enforcement. Justice Barrett's majority opinion held that universal injunctions exceed federal courts' equitable authority because they lack sufficient historical precedent in English chancery practice at the founding. The decision means that courts can only grant injunctive relief necessary to provide complete relief to the specific plaintiffs before them, potentially allowing challenged government policies to continue operating against non-parties, even when courts find those policies likely unconstitutional. In this episode, we'll examine the majority opinion alongside 3 separate concurrences from Justices Thomas, Alito, and Kavanaugh that reveal different concerns about implementation and enforcement gaps, then analyze Justice Sotomayor's dissent, arguing that universal injunctions have deep equity roots, and Justice Jackson's separate dissent warning the ruling creates dangerous zones of executive lawlessness. We'll conclude by exploring the practical implications for federal litigation and constitutional enforcement, including potential workarounds through class actions and the Supreme Court's continued role as ultimate arbiter of major federal policies. The questions presented in this case are: 1. Whether district courts have the authority to issue nationwide preliminary injunctions irrespective of class action certification. 2. Whether the Supreme Court should stay the district court's nationwide preliminary injunctions on the Trump administration's January 20th, 2025 executive order ending birthright citizenship, except as to the individual plaintiffs and identified members of the organizational plaintiffs or states. Justice Barrett delivered the opinion of the court, in which Chief Justice Roberts and Justices Thomas, Alito, Gorsuch, and Kavanaugh joined. Justice Thomas filed a concurring opinion, in which Justice Gorsuch joined. Justice Alito filed a concurring opinion, in which Justice Thomas joined. Justice Kavanaugh filed a concurring opinion. Justice Sotomayor filed a dissenting opinion, in which Justices Kagan and Jackson joined. Justice Jackson filed a dissenting opinion.
Justice Barrett's majority opinion: plaintiffs, respondents here, individuals, organizations, and states, filed 3 separate suits to enjoin the implementation and enforcement of President Trump's executive order number 14,160. The executive order identifies circumstances in which a person born in the United States is not subject to the jurisdiction thereof and is thus not recognized as an American citizen. The plaintiffs allege that the executive order violates the 14th Amendment Citizenship Clause, Section 1, and Section 201 of the Nationality Act of 1940. In each case, the district court entered a universal injunction, an injunction barring executive officials from applying the executive order to anyone, not just the plaintiffs. And in each case, the Court of Appeals denied the government's request to stay the sweeping relief. The government argues that the district courts lacked equitable authority to impose universal relief and has filed 3 nearly identical emergency applications seeking partial stays to limit the preliminary injunctions to the plaintiffs in each case. The applications do not raise, and thus the court does not address, the question whether the executive order violates the Citizenship Clause or Nationality Act. Instead, the issue the court decides is whether, under the Judiciary Act of 1789, federal courts have equitable authority to issue universal injunctions. Held, universal injunctions likely exceed the equitable authority that Congress has given to federal courts. The court grants the government's applications for a partial stay of the injunctions entered below, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff with standing to sue. A. The issue raised by these applications, whether Congress has granted federal courts authority to universally enjoin the enforcement of an executive order, plainly warrants this court's review. On multiple occasions and across administrations, the Solicitor General has asked the court to consider the propriety of this expansive remedy. As the number of universal injunctions has increased over the years, so too has the importance of the issue. B. The government is likely to succeed on the merits of its claim that the district courts lacked authority to issue universal injunctions. The issuance of a universal injunction can be justified only as an exercise of equitable authority, yet Congress has granted federal courts no such power. The Judiciary Act of 1789 endowed federal courts with jurisdiction over all suits. In equity, Section 11, 1 statute. 78 and still today, this statute is what authorizes the federal courts to issue equitable remedies. This court has held that the statutory grant encompasses only those sorts of equitable remedies traditionally accorded by courts of equity at our country's inception. Universal injunctions are not sufficiently analogous to any relief available in the Court of Equity in England at the time of the founding. Equity offered a mechanism for the Crown to secure justice where it would not be secured by the ordinary and existing processes of law. This judicial prerogative of the king thus extended to those causes which the ordinary judges were incapable of determining. Eventually, the Crown instituted the practice of delegating the cases that came before the judicial prerogative to the Chancellor for his sole decision. The general rule in equity was that all persons materially interested in the suit were to be made parties to it. Injunctions were no exception. There were sometimes suits to restrain the actions of particular officers against particular plaintiffs. Of importance here, suits in equity were brought by and against individual parties, and the Chancellor's remedies were generally party-specific. In sum, under long-standing equity practice in England, there was no remedy remotely like a national injunction, nor did founding-era courts of equity in the United States chart a different course. If anything, the approach traditionally taken by federal courts cuts against the existence of such a sweeping remedy. Consider Scott versus Donald, where the plaintiffs successfully challenged the constitutionality of a law on which state officials had relied to confiscate alcohol that the plaintiff kept for personal use. Although the plaintiff sought an injunction barring enforcement of the law against both himself and anyone whose rights were infringed and threatened by it, the court permitted only relief benefiting the named plaintiff. In the ensuing decades, the court consistently rebuffed requests for relief that extended beyond the parties. The court's early refusals to grant relief to non-parties are consistent with the party-specific principles that permeate the court's understanding of equity. Neither declaratory nor injunctive relief, the court has said, can directly interfere with enforcement of contested statutes or ordinances except with respect to the particular federal plaintiffs. In fact, universal injunctions were conspicuously non-existent for most of the nation's history. Their absence from the 18th and 19th century equity practice settles the question of judicial authority. While equity is flexible, the court's precedent emphasizes that its flexibility is confined within the broad boundaries of traditional equitable relief. Because the universal injunction lacks a historical pedigree, it falls outside the bounds of a federal court's equitable authority under the Judiciary Act. C. Respondents' counterarguments are unavailing. 1. In an effort to satisfy Grupo Mexicano's historical test, respondents claim that universal injunctions are the modern equivalent of the decree resulting from a bill of peace, a form of group litigation in the Court of Chancery. Respondents contend that the existence of this historic equitable device means that federal courts have the equitable authority to issue universal injunctions under the Judiciary Act. The analogy, however, does not work. True, bills of peace allow courts of equity to adjudicate the rights of members of dispersed groups without formally joining them to a lawsuit through the usual procedures. Unlike universal injunctions, however, which reach anyone affected by executive or legislative action, bills of peace involved a group that was small and cohesive. And unlike universal injunctions, which bind only the parties to the suit, decrees resulting from a bill of peace would bind all members of the group, whether they were present in the action or not. The Bill of Peace lives in modern form, but not as the universal injunction. It is instead analogous to the modern class action, which, in federal court, is governed by Rule 23 of the Federal Rules of Civil Procedure. Rule 23 requires numerosity, such that joinder is impracticable. Common questions of law or fact, typicality, and representative parties who adequately protect the interests of the class. The requirements for a Bill of Peace were virtually identical. By forging a shortcut to relief that benefits parties and non-parties alike, universal injunctions impermissibly circumvent Rule 23's procedural protections. 2. Respondents contend that universal injunctions, or at least these universal injunctions, are simply an application of the principle that a court of equity may fashion a remedy that awards complete relief. But complete relief is not synonymous with universal relief. It is a narrower concept, long embraced in the equitable tradition that allows courts to administer complete relief between the parties. To be sure, party-specific injunctions sometimes advantage non-parties, but they do so only incidentally. Here, prohibiting enforcement of the executive order against the child of an individual pregnant plaintiff will give that plaintiff complete relief. Her child will not be denied citizenship. And extending the injunction to cover everyone similarly situated would not render her relief any more complete. So the individual and associational respondents are wrong to characterize the universal injunction as simply an application of the complete relief principle. The inquiry is more complicated for the state respondents because the relevant injunction does not purport to directly benefit non-parties. Instead, the district court for the District of Massachusetts decided that a universal injunction was necessary to provide the states themselves complete relief. As the states see it, their harms, financial injuries, and the administrative burdens flowing from citizen-dependent benefits programs cannot be remedied without a blanket ban on the enforcement of the executive order. Children often move across state lines or are born outside their parents' state of residence. Given the cross-border flow, the states say, a patchwork injunction would prove unworkable for the provision of certain federally funded benefits. The government retorts that even if the injunction is designed to benefit only the states, it is more burdensome than necessary to redress their asserted harms, and that narrower relief is appropriate. The court declines to take up these arguments in the first instance. The lower courts should determine whether a narrower injunction is appropriate, so we leave it to them to consider these and any related arguments. 3. Respondents defend universal injunctions as a matter of policy. The government advances policy arguments running the other way. As with most questions of law, the policy pros and cons are beside the point. Under the court's well-established precedent, Se Grupo Mexicano 527 U.S. at 319, because universal injunctions lack a founding era forebear, federal courts lack authority to issue them. D. To obtain interim relief, the government must show that it is likely to suffer irreparable harm absent a stay. When a federal court enters a universal injunction against the government, it improperly intrudes on a coordinate branch of the government and prevents the government from enforcing its policies against non-parties. The court's practice also demonstrates that an applicant need not show it will prevail on the underlying merits when it seeks a stay on a threshold issue. The government here is likely to suffer irreparable harm from the district court's entry of injunctions that likely exceed the authority conferred by the Judiciary Act. And the balance of equities does not counsel against awarding the government interim relief. A partial stay will cause no harm to respondents because they will remain protected by the preliminary injunctions to the extent necessary and appropriate to afford them complete relief. E. When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power, too. The government's applications for partial stays of the preliminary injunctions are granted, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff with standing to sue. Applications for partial stays granted.
Justice Thomas's concurring opinion. I agree and join in full. As the court explains, the Judiciary Act of 1789, the statute that authorizes the federal courts to issue equitable remedies, does not permit universal injunctions. It authorizes only those remedies traditionally available in equity, and there is no historical tradition allowing courts to provide relief that extends beyond the parties. That conclusion is dispositive. If district courts have any authority to issue universal injunctions, it must come from some specific statutory or constitutional grant. But the Judiciary Act is the only real possibility, and serious constitutional questions would arise even if Congress purported to one day allow universal injunctions. I write separately to emphasize the majority's guidance regarding how courts should tailor remedies specific to the parties. Courts must not distort the rule that injunctive relief should be no more burdensome to the defendant than necessary to provide complete relief to the plaintiffs. Otherwise, they risk replicating the problems of universal injunctions under the guise of granting complete relief. The complete relief principle operates as a ceiling. In no circumstance can a court award relief beyond that necessary to redress the plaintiff's injuries. This limitation follows from both Article 3 and traditional equitable practice. Because Article 3 limits courts to resolving specific cases and controversies, it requires that any remedy be tailored to redress the plaintiff's particular injury, and equitable remedies historically operated on a plaintiff-specific basis. Accordingly, any remedy must, of course, be limited to the inadequacy that produced the injury in fact that the plaintiff has established. Courts therefore err insofar as they treat complete relief as a mandate. This principle reflects the equitable rule that courts generally may administer complete relief between the parties. It is an important aim of the law of remedies to put the plaintiff in her rightful position, but to say that a court can award complete relief is not to say that it should do so, and in some circumstances, a court cannot award complete relief. Any relief must fall within traditional limits on a court's equitable powers. Courts must ask whether the relief plaintiffs seek was traditionally accorded by courts of equity, and they must ensure that any injunctions comport with both the complete relief principle and other principles of equity. In some cases, traditional equitable limits will require courts and plaintiffs to make do with less than complete relief. An indivisible remedy is appropriate only when it would be all but impossible to devise relief that reaches only the plaintiffs. Such impossibility is a high bar. The court today readily dispatches with the individual and associational respondent's position that they require a universal injunction. As the court recognizes, prohibiting enforcement of the executive order against the child of an individual pregnant plaintiff is all that is required to give that plaintiff complete relief. Courts may not use the complete relief principle to revive the universal injunction. For good reason, the court today puts an end to the increasingly common practice of federal courts issuing universal injunctions. The court also makes clear that the complete relief principle provides a ceiling on federal courts' authority, which must be applied alongside other principles of equity, and our holding that universal injunctions are impermissible. Lower courts should carefully heed this court's guidance and cabin their grants of injunctive relief in light of historical equitable limits. If they cannot do so, this court will continue to be duty-bound to intervene.
Justice Alito's concurring opinion. I join the opinion of the court, but write separately to note two related issues that are left unresolved and potentially threaten the practical significance of today's decision: the availability of third-party standing and class certification. First, the court does not address the weighty issue whether the state plaintiffs have third-party standing to assert the citizenship clause claims of their individual residents. Ordinarily, a litigant must assert his or her own legal rights and interests and cannot rest a claim to relief on the legal rights or interests of third parties. In limited circumstances, however, the court has permitted a party to assert the rights of a third party. But at a minimum, we have said that a litigant seeking to assert the legal rights or interests of others must demonstrate ordinary Article 3 standing for itself, and answer the additional threshold question whether it has standing to raise the rights of others. This latter requirement entails a showing that the litigant has a close relationship to the right holder and that there is some hindrance to the right holder's ability to protect his own interests. So long as third-party standing doctrine remains good law, federal courts should take care to apply these limitations conscientiously, including against state plaintiffs. That is especially so in cases such as these, in which the parties claiming third-party standing, i.e. the states, are not directly subject to the challenged policy in the relevant respect and face, at most, collateral injuries. Today's decision only underscores the need for rigorous and even-handed enforcement of third-party standing limitations. The court holds today that injunctive relief should generally extend only to the suing plaintiff. That will have the salutary effect of bringing an end to the practice of runaway universal injunctions, but it leaves other questions unanswered. Perhaps most important, when a state brings a suit to vindicate the rights of individual residents and then procures injunctive relief, does the injunction bind the defendant with respect to all residents of that state? If so, states will have every incentive to bring third-party suits on behalf of their residents to obtain a broader scope of equitable relief than any individual resident could procure in his own suit. Left unchecked, the practice of reflexive state third-party standing will undermine today's decision as a practical matter. Second, today's decision will have very little value if district courts award relief to broadly defined classes without following Rule 23's procedural protections for class certification. The class action is a powerful tool, and we have accordingly held that class certification is proper only if the trial court is satisfied, after a rigorous analysis, that the prerequisites of Rule 23A have been satisfied. These requirements are more than a mere pleading standard, and a hasty application of Rule 23 of the Federal Rules of Civil Procedure can have drastic consequences, creating potential unfairness for absent class members and confusion and pressure to settle for defendants.
Putting the kibosh on universal injunctions does nothing to disrupt Rule 23's requirements. Of course, Rule 23 may permit the certification of nationwide classes in some discrete scenarios, but district courts should not view today's decision as an invitation to certify nationwide classes without scrupulous adherence to the rigors of Rule 23. Otherwise, the universal injunction will return from the grave under the guise of nationwide class relief, and today's decision will be of little more than minor academic interest.
Lax enforcement of the requirements for third-party standing and class certification would create a potentially significant loophole to today's decision. Federal courts should thus be vigilant against such potential abuses of these tools. I do not understand the court's decision to reflect any disagreement with these concerns, so I join its decision in full.
Justice Kavanaugh's concurring opinion. The plaintiffs here sought preliminary injunctions against enforcement of the President's executive order on birthright citizenship. The district courts granted universal preliminary injunctions, that is, injunctions prohibiting enforcement of the executive order against anyone. Under the court's holding today, district courts issuing injunctions under the authority afforded by the Judiciary Act of 1789 may award only plaintiff-specific relief. I join the court's careful and persuasive opinion, which will bring needed clarity to the law of remedies. To be sure, in the wake of the court's decision, plaintiffs who challenge the legality of a new federal statute or executive action and request preliminary injunctive relief may sometimes seek to proceed by class action under Federal Rule of Civil Procedure 23b2 and ask a court to award preliminary class-wide relief that may, for example, be statewide, region-wide, or even nationwide. And in cases under the Administrative Procedure Act, plaintiffs may ask a court to preliminarily set aside a new agency rule. But importantly, today's decision will require district courts to follow proper legal procedures when awarding such relief. Most significantly, district courts can no longer award preliminary nationwide or class-wide relief except when such relief is legally authorized.
and that salutary development will help bring substantially more order and discipline to the ubiquitous preliminary litigation over new federal statutes and executive actions. I write separately simply to underscore that this case focuses on only one discrete aspect of the preliminary litigation relating to major new federal statutes and executive actions, namely what district courts may do with respect to those new statutes and executive actions in what might be called the interim before the interim. Although district courts have received much of the attention and criticism in debates over the universal injunction issue, those courts generally do not have the last word when they grant or deny preliminary injunctions. The courts of appeals and this court can, and regularly do, expeditiously review district court decisions awarding or denying preliminary injunctive relief. This court has therefore often acted as the ultimate decider of the interim legal status of major new federal statutes and executive actions. After today's decision, that order of operations will not change. In justiciable cases, this court, not the district courts or courts of appeals, will often still be the ultimate decision maker as to the interim legal status of major new federal statutes and executive actions. That is, the interim legal status for the several-year period before a final decision on the merits. The court's decision today focuses on the interim before the interim, the preliminary relief that district courts can award and courts of appeals can approve for the generally weeks-long interim before this court can assess and settle the matter for the often years-long interim before a final decision on the merits. The basic scenario in these kinds of applications to this court is by now familiar. Congress passes a major new statute, or the executive branch issues a major new rule or executive order. The litigation over the legality of the new statute or executive action winds its way through the federal courts, and that litigation may meander on for many months or often years before this court can issue a final ruling deciding the legality of the new statute or executive action. And in the meantime, various plaintiffs may seek preliminary injunctions, sometimes in many different district courts. That preliminary injunction litigation raises a question: what should the interim legal status of the significant new federal statute or executive action at issue be during the several-year period before this court's final ruling on the merits? That interim status question is itself immensely important. The issue of whether a major new federal statute or executive action is enforceable during the several years while the parties wait for a final merits ruling raises a separate question of extraordinary significance to the parties and the American people. First, in my view, there often, perhaps not always, but often, should be a nationally uniform answer on whether a major new federal statute, rule, or executive order can be enforced throughout the United States during the several-year interim period until its legality is finally decided on the merits. Often it is not especially workable or sustainable or desirable to have a patchwork scheme, potentially for several years, in which a major new federal statute or executive action of that kind applies to some people or organizations in certain states or regions, but not to others. The national reach of many businesses and government programs, as well as the regular movement of the American people into and out of different states and regions, would make it difficult to sensibly maintain such a scattershot system of federal law. Second, if one agrees that the years-long interim status of a highly significant new federal statute or executive action should often be uniform throughout the United States, who decides what the interim status is? The answer typically will be this court, as has been the case both traditionally and recently. This court's actions in resolving applications for interim relief help provide clarity and uniformity as to the interim legal status of major new federal statutes, rules, and executive orders. In particular, the court's disposition of applications for interim relief often will effectively settle, de jure or de facto, the interim legal status of those statutes or executive actions nationwide. The decision today will not alter this court's traditional role in those matters. When a stay or injunction application arrives here, this court should not and cannot hide in the tall grass. When we receive such an application, we must grant or deny. And when we do, that is, when this court makes a decision on the interim legal status of a major new federal statute or executive action, that decision will often constitute a form of precedent, de jure or de facto, that provides guidance throughout the United States during the years-long interim period until a final decision on the merits. It is sometimes suggested, however, that this court should adopt a policy of presumptively denying applications for stays or injunctions, even applications involving significant new federal statutes or executive actions, regardless of which way the various lower courts have ruled. That suggestion is flawed, in my view, because it would often leave an unworkable or intolerable patchwork of federal law in place. One of this court's roles, in justiciable cases, is to resolve major legal questions of national importance and ensure uniformity of federal law. So a default policy of offloading to lower courts the final word on whether to green light or block major new federal statutes and executive actions for the several-year interim until a final ruling on the merits would seem to amount to an abdication of this court's proper role. The volume of preliminary injunction and other pre-enforcement litigation over new federal laws and executive actions coming to this court has been growing in recent years. Although the volume of applications has increased, the court's responsibility for deciding consequential applications for stays or injunctions is not new. Today's decision on district court injunctions will not affect this court's vitally important responsibility to resolve applications for stays or injunctions with respect to major new federal statutes and executive actions. Deciding those applications is not a distraction from our job. It is a critical part of our job. With that understanding, I join the court's opinion in full.
Justice Sotomayor's dissenting opinion: children born in the United States and subject to its laws are United States citizens. That has been the legal rule since the founding, and it was the English rule well before then. This court once attempted to repudiate it, holding in Dred Scott versus Sanford that the children of enslaved Black Americans were not citizens. To remedy that grievous error, the states passed in 1866 and Congress ratified in 1868 the 14th Amendment's Citizenship Clause, which enshrined birthright citizenship in the Constitution. There it has remained, accepted and respected by Congress, by the executive, and by this court, until today. It is now the president who attempts in an executive order to repudiate birthright citizenship. Every court to evaluate the order has deemed it patently unconstitutional and, for that reason, has enjoined the federal government from enforcing it. Undeterred, the government now asks this court to grant emergency relief, insisting it will suffer irreparable harm unless it can deprive at least some children born in the United States of citizenship. The government does not ask for complete stays of the injunctions, as it ordinarily does before this court. Why? The answer is obvious. To get such relief, the government would have to show that the order is likely constitutional, an impossible task in light of the Constitution's text, history, this court's precedents, federal law, and executive branch practice. So the government instead tries its hand at a different game. It asks this court to hold that no matter how illegal a law or policy, courts can never simply tell the executive to stop enforcing it against anyone. The gamesmanship in this request is apparent, and the government makes no attempt to hide it. Yet, shamefully, this court plays along. A majority of this court decides that these applications, of all cases, provide the appropriate occasion to resolve the question of universal injunctions and end the centuries-old practice once and for all. In its rush to do so, the court disregards basic principles of equity as well as the long history of injunctive relief granted to non-parties. No right is safe in the new legal regime the court creates. Today, the threat is to birthright citizenship. Tomorrow, a different administration may try to seize firearms from law-abiding citizens or prevent people of certain faiths from gathering to worship. The majority holds that absent cumbersome class action litigation, courts cannot completely enjoin even such plainly unlawful policies unless doing so is necessary to afford the formal parties complete relief, that holding renders constitutional guarantees meaningful in name only for any individuals who are not parties to a lawsuit, because I will not be complicit in so grave an attack on our system of law, I dissent. The Citizenship Clause provides that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That means what it says. Besides birth, there is only one condition, that one be subject to the jurisdiction of the United States. Yet that condition, too, leaves no room for ambiguity. To be subject to the jurisdiction of the United States means simply to be bound to its authority and its laws. Few constitutional questions can be answered by resort to the text of the Constitution alone, but this is one. The 14th Amendment guarantees birthright citizenship. Following the ratification of the 14th Amendment, this court confirmed the amendment's plain meaning in United States versus Wong Kim Ark. This court held that the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory. The subject to the jurisdiction qualifier excludes only children born of alien enemies in hostile occupation and children of diplomatic representatives of a foreign state, with the single additional exception of children of members of the Indian tribes owing direct allegiance to their several tribes. That holding conclusively settled any remaining dispute over the Citizenship Clause's meaning. Since then, all three branches of government have unflinchingly adhered to it. A majority of this court nonetheless rushes to address the merits of the government's applications, holding that universal injunctions likely exceed the equitable authority that Congress has granted to federal courts. A majority that has repeatedly pledged its fealty to history and tradition thus eliminates an equitable power firmly grounded in centuries of equitable principles and practice. By stripping all federal courts, including itself, of that power, the court kneecaps the judiciary's authority to stop the executive from enforcing even the most unconstitutional policies. The American legal system grew out of English law, which had two primary judicial institutions, the common law courts and equity courts. Equity courts arose because of the inflexibility of the common law system. Their purpose was to look beyond formal writs and provide remedies where the common law gave inadequate relief. Adaptability has always been a hallmark of equity, especially with regard to the scope of its remedies. While common law courts were compelled to limit their inquiry to the very parties in the litigation before them, equity courts could adjust the rights of all, however numerous, and adapt their decrees to all the varieties of circumstances which may arise and adjust them to all the peculiar rights of all the parties in interest. After all, equity's constant aim was to do complete justice. In their pursuit of complete justice, equity courts could award injunctive and other equitable relief to parties and non-parties alike. For centuries, they did so through what was known as bills of peace. If a plaintiff or group of plaintiffs filed such a bill, an English court could use a single case to settle disputes affecting whole communities, for the inherent jurisdiction of equity included the power to interfere for the prevention of a multiplicity of suits. Federal courts have also exercised equitable authority to enjoin universally federal and state laws for more than a century. The universal injunctions of the citizenship order fit firmly within that tradition. The majority's contrary reasoning falls flat. The majority starts with the Judiciary Act of 1789, which gives federal courts jurisdiction over all suits. In equity, in the majority's telling, universal injunctions are inconsistent with equity jurisdiction because they are not sufficiently analogous to the relief exercised by the High Court of Chancery in England at the time of the adoption of the Constitution and the enactment of the original Judiciary Act. The majority fundamentally misunderstands the nature of equity by freezing in amber the precise remedies available at the time of the Judiciary Act, even as it declares that equity is flexible. The majority ignores the very flexibility that historically allowed equity to secure complete justice where the rigid forms of common law proved inadequate. Even the majority's view of the law cannot justify issuance of emergency relief to the government in these cases, for the majority leaves open whether these particular injunctions may pass muster under its ruling. Indeed, the lower courts issued the challenged injunctions consistent with an equitable principle that even the majority embraces. Courts may award an equitable remedy when it is necessary to provide complete relief to the plaintiffs. The equities and public interest weigh decisively against the government. For all of the reasons discussed, the citizenship order is patently unconstitutional. To allow the government to enforce it against even one newborn child is an assault on our constitutional order and antithetical to equity and public interest. The court's decision is nothing less than an open invitation for the government to bypass the Constitution. The executive branch can now enforce policies that flout settled law and violate countless individuals' constitutional rights, and the federal courts will be hamstrung to stop its actions fully. Until the day that every affected person manages to become party to a lawsuit and secures for himself injunctive relief, the government may act lawlessly indefinitely. The rule of law is not a given in this nation, nor any other. It is a precept of our democracy that will endure only if those brave enough in every branch fight for its survival. Today, the court abdicates its vital role in that effort. With the stroke of a pen, the president has made a solemn mockery of our Constitution. Rather than stand firm, the court gives way. Because such complicity should know no place in our system of law, I dissent.
Justice Jackson's dissenting opinion: I agree with every word of Justice Sotomayor's dissent. I write separately to emphasize a key conceptual point. The court's decision to permit the executive to violate the Constitution with respect to anyone who has not yet sued is an existential threat to the rule of law. It is important to recognize that the executive's bid to vanquish so-called universal injunctions is, at bottom, a request for this court's permission to engage in unlawful behavior. When the government says, do not allow the lower courts to enjoin executive action universally as a remedy for unconstitutional conduct, what it is actually saying is that the executive wants to continue doing something that a court has determined violates the Constitution. Please allow this. That is some solicitation. With its ruling today, the majority largely grants the government's wish. But in my view, if this country is going to persist as a nation of laws and not men, the judiciary has no choice but to deny it. Stated simply, what it means to have a system of government that is bounded by law is that everyone is constrained by the law, no exceptions. And for that to actually happen, courts must have the power to order everyone, including the executive, to follow the law, full stop. To conclude otherwise is to endorse the creation of a zone of lawlessness within which the executive has the prerogative to take or leave the law as it wishes, and where individuals who would otherwise be entitled to the law's protection become subject to the executive's whims instead. Focusing on inapt comparisons to impotent English tribunals, the majority ignores the judiciary's foundational duty to uphold the Constitution and laws of the United States. The majority's ruling thus not only diverges from first principles, it is also profoundly dangerous, since it gives the executive the go-ahead to sometimes wield the kind of unchecked arbitrary power the founders crafted our Constitution to eradicate. To hear the majority tell it, this suit raises a mind-numbingly technical query. Are universal injunctions sufficiently analogous to the relief issued by the High Court of Chancery in England at the time of the adoption of the Constitution and the enactment of the original Judiciary Act to fall within the equitable authority Congress granted federal courts in the Judiciary Act of 1789? But that legalese is a smokescreen. It obscures a far more basic question of enormous legal and practical significance. May a federal court in the United States of America order the executive to follow the law? To ask this question is to answer it. In a constitutional republic such as ours, a federal court has the power to order the executive to follow the law, and it must. It is axiomatic that the Constitution of the United States and the statutes that the people's representatives have enacted govern in our system of government. Thus, everyone from the president on down is bound by law. The founders of the United States of America squarely rejected a governing system in which the king ruled all, and all others, including the courts, were his subordinates. In our Constitution-centered system, the people are the rulers and we have the rule of law. So, it makes little sense to look to the relationship between English courts and the king for guidance on the power of our nation's judiciary vis-a-vis its executive. Indeed, it is precisely because the law constrains the government in our system that the judiciary's assignment is so broad per the Constitution. Federal courts entertain suits against the government claiming constitutional violations. Thus, the function of the courts, both in theory and in practice, necessarily includes announcing what the law requires in such suits for the benefit of all who are protected by the Constitution, not merely doling out relief to injured private parties. The majority views the judiciary's power through an aperture that is much too small, leading it to think that the only function of our courts is to provide complete relief to private parties. Sure, federal courts do that and they do it well, but they also diligently maintain the rule of law itself. When it comes to upholding the law, federal courts ensure that all comers, i.e., everyone to whom the law applies, and over whom the court has personal jurisdiction, including and perhaps especially the executive, know what the law is, and most important, follow it. What I mean by this is that our rights-based legal system can only function properly if the executive and everyone else is always bound by law. Today's decision is a seismic shock to that foundational norm. Allowing the executive to violate the law at its prerogative with respect to anyone who has not yet sued carves out a huge exception, a gash in the basic tenets of our founding charter that could turn out to be a mortal wound. What the executive wants, in effect, is for this court to bless and facilitate its desire to operate in two different zones moving forward. One in which it is required to follow the law because a particular plaintiff has secured a personal injunction prohibiting its unlawful conduct, and another in which it can choose to violate the law with respect to certain people, those who have yet to sue. I am not the first to observe that a legal system that operates on two different tracks, one of which grants to the executive the prerogative to disregard the law, is anathema to the rule of law. Thus, the law-free zone that results from this court's near elimination of universal injunctions is not an unfamiliar archetype. Consequently, the zone of lawlessness the majority has now authorized will disproportionately impact the poor, the uneducated, and the unpopular, i.e., those who may not have the wherewithal to lawyer up and will all too often find themselves beholden to the executive's whims. The bottom line is this: if courts do not have the authority to require the executive to adhere to law universally, a dual-track system develops in which courts are ousted as guardians in some situations, and compliance with law sometimes becomes a matter of executive prerogative. But there can be no free society without law administered through an independent judiciary. If one man, even a very important man, and even a democratically elected man, can be allowed to determine for himself what is law, every man can. That means first chaos, then tyranny. A concrete example helps to illustrate why this turnabout undermines the rule of law. Imagine an executive who issues a blanket order that is blatantly unconstitutional, demanding, say, that any and all of its political foes be summarily and indefinitely incarcerated in a prison outside the jurisdiction of the United States, without any hearing or chance to be heard in court. The upshot of today's decision is that despite that rival's success in persuading a judge of the unconstitutional nature of the executive's proclamation, the court's ruling and injunction can only require the executive to shelve any no-process incarceration plan that targets that particular individual, the named plaintiff. The executive can keep right on rounding up its other foes, despite the court's clear and unequivocal pronouncement that the executive order is unlawful. I view the demise of the notion that a federal judge can order the executive to adhere to the Constitution, full stop, as a sad day for America. The majority's unpersuasive effort to justify this result makes it sadder still. It is the responsibility of each and every jurist to hold the line, but the court now requires judges to look the other way after finding that the executive is violating the law, shamefully permitting unlawful conduct to continue unabated. Make no mistake, today's ruling allows the executive to deny people rights that the founders plainly wrote into our Constitution, so long as those individuals have not found a lawyer or asked a court in a particular manner to have their rights protected. This perverse burden shifting cannot coexist with the rule of law. In essence, the court has now shoved lower court judges out of the way in cases where executive action is challenged and has gifted the executive with the prerogative of sometimes disregarding the law. The accretion of dangerous power does not come in a day, but it does come from the generative force of unchecked disregard of the restrictions that fence in even the most disinterested assertion of authority. By needlessly granting the government's emergency application to prohibit universal injunctions, the court has cleared a path for the executive to choose law-free action at this perilous moment for our Constitution, right when the judiciary should be hunkering down to do all it can to preserve the law's constraints. With deep disillusionment, I dissent.
All right. Those were the majority, concurring and dissenting opinions. Now let's talk case implications. The Supreme Court's decision in Trump versus Casa fundamentally reshapes the landscape of federal injunctive relief by constraining district courts' authority to issue universal injunctions that halt government policies nationwide. While the majority frames this as a restoration of historical equity practice, the practical implications extend far beyond remedial procedure. Justice Alito's concurrence highlights critical enforcement gaps that could undermine the decision's effectiveness, warning that states may circumvent the ruling through expansive third-party standing claims or that district courts might achieve similar results through hastily certified nationwide class actions under Rule 23. Justice Kavanaugh's concurrence acknowledges this reality, noting that the decision primarily affects the interim before the interim, the brief period before cases reach the Supreme Court, which he suggests will continue serving as the ultimate arbiter of major federal policy's nationwide status through its emergency docket. The dissenting opinions reveal the profound constitutional tensions the majority's approach creates. Justice Sotomayor's dissent demonstrates how the ruling potentially fragments constitutional enforcement, allowing executive policies to operate in a legal patchwork where compliance depends on individual litigation capacity rather than uniform legal standards. Justice Jackson's dissent raises even starker concerns about dual-track governance, where constitutional protections become contingent on plaintiffs' ability to secure individual relief. Justice Thomas's concurrence attempts to cabin these concerns by emphasizing that complete relief remains available to individual plaintiffs, but the dissenters suggest this creates an inherently unstable system where constitutional rights exist more in theory than practice for those unable to access federal court. The decision's ultimate impact may depend less on its doctrinal boundaries than on how lower courts, litigants, and the executive branch adapt to navigate these new constraints while preserving meaningful constitutional enforcement. Thanks for listening to this episode. I'll be back soon with more Supreme Court analysis. If you found this valuable, please subscribe and share with anyone who wants to understand how the court really shapes our lives. Talk to you soon.